With me today is Tim Pierce, Ethics Counsel for the State Bar, and my name is Dean Dietrich, Chair of the Committee on Professional Ethics for the State Bar. Our program today talks about moving on ethical considerations when leaving a law firm. And Tim and I are going to visit today about some of the issues that arise when a lawyer is contemplating and then decides to move from one law firm to another law firm. Tim, I think I want to start by asking you to comment just on the topic in general. I think we're seeing a lot of what I would call lawyer movement within the legal community, and I think that brings a lot of questions to you on the ethics hotline.
It does, and it's an interesting topic in that lawyers perceive it, and correctly, as being fraught with ethical pitfalls. However, if you actually look at the rules of professional conduct, you see nothing that seems to address this. There is no rule that governs lawyer departure from firms. In fact, it is not even mentioned anywhere in the rules or the comment. So while you sort of have it drummed into you by experience and sort of interactions with other lawyers, oh, you can't do that when you leave, it's quote-unquote unethical, or you can't do this when you leave, that's unethical. The rules itself do not, at least at first blush, seem to address that.
But I think it's fair to say that there are some very general principles that you start out with when you're considering the process of moving from one place to another place. And we identify them in an outline that we have. And the first one, Tim, is nobody really owns the client. The client has really the say here. How does that relate to, we're providing services to the client. Doesn't the providing of services create some sort of, we certainly have a duty of loyalty. Doesn't that work the other way?
No. Clients have no duty of loyalty to their lawyers or the firms that those lawyers work for. And it is a well-established principle, both in the disciplinary rules and civil law, that clients have a right to counsel of their choice, and they have the absolute right to fire their lawyer, to discharge their lawyer at any time, for any reason or for no reason whatsoever. Lawyers transition from private firm to private firm, and what do they want to do? They want to take the clients that they've established the relationships with over the time they spent at the firm. And the firm, conversely, views those clients as, wow, they are clients of the firm. We brought in this associate, we put in the time and effort in training them, and we have a right to our clients. That view, however, is completely wrong. Lawyers have absolutely no possessory interest or right to the current or future representation of any client. You have no right to expect to be able to represent a client in the future if a client decides otherwise. You have a right to be reasonably compensated for the services you have already provided, but you have no right to say, this client belongs to me, or that client belongs to you. That's a nonsensical statement in the meaning of the law.
And Tim, I've been asked over the years to give different types of testimony, and sometimes that question is posed regarding kind of the right to the client, or the statement that the client gets to choose the attorney of their own choosing, and they have that freedom of whatever choice they wish. It's really not stated anywhere in the rules, but it's kind of a fundamental component of the lawyer-client relationship, right?
That's correct. It is stated somewhat indirectly in that, I referenced, without citing the rule, Rule 1.16, subsection A, which imposes an obligation on the lawyer of mandatory withdrawal whenever the lawyer is discharged. So if the client says, you're through because I want somebody else, you violate that disciplinary rule if you say, hey, wait a minute, you can't fire me. And lawyers in Wisconsin have been disciplined for refusing to abide by clients' direction on that.
Seems to be the way to get around that, or the way people try to get around that kind of unalienable right of the client to make that choice, is to seek to exercise control over the file. And I think, Tim, you and I are very often asked questions about the file and who owns the file, and what about the content of the file? Who is entitled to the content of the file? Again, I think there's a pretty basic principle that we would rely upon when responding to that.
Wisconsin law is clear. The file is the property of the client, not the lawyer. There is no attorney's liens on files in Wisconsin. Doesn't exist. So the short answer is the file is the property of the client. So you look at it as something you hold in trust for the client. And like any other trust property, when the client asks for it, you have a duty of prompt delivery.
As we draw close to our program, I want to thank Tim for spending the time with us today. I want to thank you for being part of our audience today. We hope that the information has been helpful to you. On behalf of Pinnacle and the Committee on Professional Ethics of the State Bar, we thank you for being with us today.